Hey my dear learners, welcome back to my YouTube channel. Today we are going to complete the topic of fundamental rights. So let's get started. We are going to see Article 25. We have discussed up till Article 24 in the last lesson. If you haven't watched it, I'll put the link in the description box. So Article 25 guarantees the freedom of conscience, the freedom of profess, practice and propagate religion to all citizens. The above mentioned freedoms are subject to public order, health and morality. This article also gives a provision that state can make laws to regulate and restrict any financial, economic, political or other secular activity associated with any religious practice that provides for the social welfare and reform or opening up of Hindu religious institutions of a public character to all sections and classes of Hindus. Further, under this provision, Hindus are construed as including the people professing the Sikh, Jain or Buddhist religions, and Hindu institutions shall also be construed accordingly. People of Sikh faith wearing and carrying the kirpan shall be considered as included in the profession of Sikh religion, which is unlike a country like France, where religious symbols are not allowed to be worn in public. Now, Article 26, freedom to manage religious affairs. Now, this article gives the right to form and maintain institutions for religious and charitable purposes. The right to manage its own affair in the matter of religion is also provided. The right to acquire the immovable and movable property is also given by Article 26. Freedom to administer such property, religious property, according to law is also provided by this article. Article 27, freedom as to payment of taxes for promotion of any particular religion. Now, according to this article, there can be no taxes, the proceeds of which are directly used for the promotion and or maintenance of any particular religion or religious denomination. Article 28, freedom as to attendance at religious instruction or religious worship in certain educational institutions. For example, a school is affiliated with Arya Samaj or it is a Christian school. Okay, so majority of the students are coming from the religious community. ऐसे schools में it is allowed to disseminate religious instructions. But if it is a state-run school, religious instructions are not permitted to be disseminated among the students. There is an exception to this clause, this provision. If an educational institution is administered by the state government, but it has been established by a religious institution or a trust that requires religious instructions to be imparted along with education to the students, then they will be allowed to do so. Further, any person who attends any educational institution recognized by the state or receiving state aid shall not be required to participate in any religious instruction that may be imparted in such institution or also attend any religious worship in such institutions unless he or she has given consent for the same. If a student is a minor, the guardians should have given the consent for the same. Now, what is secularism? I want you to understand this before we move further. The word secularism means separate religion. It entails separation of religion from government, social, economic and cultural aspects of life. Your religion is an entirely personal matter. India is a secular country with no state religion. In India, every religion and faith is equally respected. The word is also a part of basic structure of the Constitution, which was added by the 42nd Constitutional Amendment Act. Secularism enjoys high regard in Indian democracy. Therefore, it is an inalienable part of Indian culture as seen by multitude of faiths that have coexisted in this country for centuries. All religious groups in India have the same powers without any discrimination. Now coming to cultural and educational rights, Article 29 and 30. So Article 29 is all about protection of interests of minorities. So Article 29 subclause 1 talks about providing all the citizens of the group belonging to a distinct culture, language and script right to conserve their culture and language. This right is absolute and there are no reasonable restrictions in interest of general public here. Article 29 subclause 2, the state shall not deny admission into educational institutes maintained by it or those that receive aids from it to any person based on race, religion, caste, language, etc. Now remember this, that this right is given to an individual and not any community. Now let's talk about Article 30, right of minorities to establish and administer educational institutions. Remember this, that Article 30 is also called Charter of Education Rights. Now, Article 30 subclause 1 states that all religious and linguistic minorities have the right to establish and administer their own educational institutions. Article 30 subclause 2 states that the state should not, when granting aid to educational institutions, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. Now, right to constitutional remedies, Article 32 to 35. Now, it is all about writ. Writ hota kya hai? Writs are written orders issued by Supreme Court of India to provide constitutional remedies to protect the fundamental rights of the citizens from a violation. Before I explain you all the writs in detail, let me give you some important facts about writs. Article 32 empowers Parliament to authorize any other court to issue these writs. Before 1950, only the High Courts of Calcutta, Bombay and Madras had the power to issue writs. Article 226 empowers all the High Courts of India to issue writs. Writs of India are borrowed from English law, where they are known as prerogative writs. Now let's look at type of writs. The Constitution empowers the Supreme Court and the High Courts to issue orders or writs. Habeas corpus, certiorari, prohibition, mandamus and quo warranto. Habeas corpus. Habeas corpus is a writ that is enforced to protect the fundamental right to liberty of an individual against unlawful detention. This writ commands a public official to deliver a detained person in front of the court and provide valid reasons for the detention. However, this writ cannot be issued in case the proceeding is for contempt of a legislature or a court. Certiorari. This writ of certiorari is issued to a lower court. Basically, it is to overrule the judgment given by a lower court. The Supreme Court issues the writ of certiorari in case the decision passed by the lower court is challenged by the party. So it is issued in the case if a higher court finds a matter of over jurisdiction or lack of jurisdiction. It is one of the mechanisms by which the fundamental rights of the citizen are upheld. Prohibition. Now this writ is issued by a higher court to a lower court. So if a higher court finds out that a lower court has surpassed its jurisdiction, then the higher court will issue this writ. Further, writ of prohibition can only be issued against judicial and quasi-judicial authorities. Now let's talk about mandamus. So this writ is issued to a subordinate court, an officer of the government, or a corporation or other institution, commanding them to perform certain acts or duties. Unlike habeas corpus, mandamus cannot be issued against a private individual. The writ of mandamus can be issued to order the completion of the task. The last writ, quo warranto. So now this is issued against a person who claims or usurps a public office. Usurp करने का मतलब है किसी का हक ले लेना या जब्त कर लेना. Through this writ, the court inquires by what authority the person supports his or her claim. Through this writ, the court inquires into the legality of a claim of a person to a public office. This writ prevents the illegal assumption of public office by an individual. Now let's conclude the lesson with a very important topic, suspension of fundamental rights. FRs can be suspended in the case of national emergency as mentioned under Article 352. The 6 fundamental rights under Article 19 are automatically suspended in case of national emergency that is imposed on the grounds of war or external aggression, which is stated under Article 358. Article 359 has the clause for suspension of other rights. In that case, a separate notification has to be issued by the President. Rights mentioned under Article 20 and 21 can never be suspended. Constitutional emergency and financial emergency cannot affect the fundamental rights. Remember all these points. So that is it for today. Thank you so much for watching. यहाँ तक video देख लिया है, so please don't forget to like, share, comment and please subscribe to the YouTube channel. And don't forget the slogan, our slogan, we can do it. You all can achieve whatever you dream of. I'll see you in the next one.